Question B now put.
From Andrew Little.
Chairman, I just wanted to conclude the comments I started making before and just say this, that the last thing that we need to understand what is going on with this bill and with the changes to the Care of the Children Act is finger-wagging piety from the Minister. It does not help for families, particularly those who are going through the very stressful and very difficult time, to hear from the Minister that they should pull the socks up and sort it out themselves, as if they're some sort of, Gary McCormick pull-yourself-together party sort of arrangement. That doesn't help. The stark reality is that family separation is one of the most stressful and difficult experiences, not only for the couples involved, but for any children involved as well. And it does not help for the Minister simply to say people are grown up and they should sort it out. The truth is they don't. They didn't before 1981, and the problems were getting worse and worse, and it was clogging up the High Court, and different parts of the problems were being sorted out in different parts of the court. And it won't fix it up now if we take away the very things that have actually assisted a lot more families, a lot more couples, to sort out their problems, because that's what this bill is doing. Simply telling folks, just grow up and sort it out, does not fix the problem in front of them. And people, when they are in the process of making arrangements that have legal effects and a legal impact, are entitled and must have legal advice. People genuinely know, or perhaps they don't understand the extent of it, but when you get married or when you get into a relationship, a long-term relationship, and the nature of marriage, you are creating legal consequences for yourself and your partner. And then when that unravels and comes apart, there are legal effects that have to be taken care of as well. That's why we have a family court. That's why we have a family law framework. And when we make changes to it, we better understand that those aspects that are driven by and surrounded by natural human emotion need to be treated very carefully, especially when there are children involved. And it is the height of sort of patronising nonsense for the Minister to say, oh, well, they loved each other enough to come together and they loved each other enough to have a child and therefore they can sort it out. That is ridiculous. That is ridiculous. It is because they once loved each other so much, and it is because they both committed to a child or children, that when that unravels, it gets very difficult to hold on to a sense of perspective. That is why people go to sources of independent advice. And those who don't have the means need to look to legal aid to get access to that advice, so that they can make decisions, so they can get perspective, so they can help themselves and their children and the community at large. Because it does not serve the interests of the community for there to be families who are in constant disputation with each other. Now, if there was any further evidence required that this bill is totally about transferring the cost of family disputation from those bits picked up by the state at the moment to families, you only have to have a look at clause 21. Now, we already know that cost of counselling is being reduced. We already know that there is a new charge being introduced for the mandatory family dispute resolution for cases not involving allegations of violence. We already know that legal aid is being cut. And now we also know that when the court feels it has to appoint a lawyer to assist families in final settlement or issues before them, that those costs will be apportioned between the couple themselves. And that the exclusion is when not just if the court finds there's hardship, but only if there is serious hardship. And serious hardship is defined in the Act. It sets a very high threshold. This is all about putting the cost presently correctly picked up by the state, because the public have an interest in effective and efficacious family dispute resolution, all those costs now being landed back onto the parties themselves, irrespective of their means to pay. And that is the insidious nature of this, and this will drive families to agree to settlements that do not suit them, that are not suitable for the children. It will drive couples to enter into these processes without the benefit of legal advice and assistance, and that will cost the community in other ways. That's the dreadful thing about this legislation. That's why we remain opposed to it. I think the one redeeming aspect of all of this is David Clendon's SOP, which confirms at least the priority and the paramountcy of children's interests and what in that important part, the principles part of the bill. That is the only thing we can bring ourselves to support, but the rest of the bill is a dog and we're opposed to it.
Jamie Lee Ross.
Move that the question be now
The
put.
question is that the question be now put. Those of that opinion will say aye. To the contrary, no. The ayes have it. Party votes called for. Ask the clerk for a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
34 opposed.
Green Party.
14 votes opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 in favour.
Mana.
1 opposed.
ACT New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan.
1 opposed.
Members, the ayes are 63, the noes are 57. The question will be put. We first have the Minister's amendments to Part 1 as set out on SOP number 349. The question is that the amendments be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. Party votes called for. I'll ask the clerk for a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
34 opposed.
Green Party.
14 votes opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 opposed.
Mana.
1 opposed.
ACT New
1
Zealand.
in favour.
United
1 in
Future.
favour.
Brendan Horan.
1 opposed.
Members, the ayes are 61, the noes are 59. The Minister's amendments are agreed to. We now have an amendment in the name of David Clendon to Clause 4, as set out on SOP number 254. The question is that the amendment be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The noes have it. A party vote's called for. I'll ask the clerk for a party vote.
New Zealand National.
59 opposed.
In favour? 34.
New Zealand Labour.
34 in favour.
Green Party.
14 votes in favour.
New Zealand First.
7 votes in favour.
Māori Party.
2 opposed.
Mana.
1 in favour.
ACT New Zealand.
1 opposed.
United Future.
1 opposed.
Brendan Horan.
1 in favour.
Members, the ayes are 57, the noes are 63. The amendment is not agreed to. The question now is that Part 1 is amended stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. So party vote's called for. Ask the clerk for a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
34 opposed.
Green Party.
14 votes opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 opposed.
Mana.
1 opposed.
ACT New
1 in
Zealand.
favour.
United
1 in
Future.
favour.
Brendan Horan.
1 opposed.
Members, the ayes are 61, the noes are 59. Part 1 is amended, will stand part. We now move to Part 2. This is debate on clauses 33 to 55. The question is that Part 2 stand part. The Honourable Judith Collins.
Mr Chair, Part 2 amends the Domestic Violence Act 1990.